Welcome everyone to our event, Leveraging AI and Prompt Engineering in Legal Tech. I'm Amit Binot, a director of the Legal Tech chapter of the Founder Institute, and also a venture capitalist at Runway 6 Ventures and Loyal VC, which has made over 100 investments in Founder Institute graduates. I'm also a former founder myself and ex-corporate lawyer, so I love hearing about new technologies that solve so many of the pain points that I used to see during my time as a lawyer. I'm joined by my colleague, Halal Garchek, who's also a director at FI. She'll be active in the chat, sharing all of our LinkedIn information. So please feel free to add us and also feel free to share your info and even the city that you're joining from, as this is a great networking opportunity to meet like-minded people. And today we're honored to have some amazing speakers who are experts in AI, which is a very hot topic. I just saw a stat from CB Insights that generative AI startups have raised over $14 billion in 2023. That's definitely an outlier in today's fundraising climate. So I'm sure we're all very excited to hear our speakers. But before I ask them to introduce themselves, I just wanted to build on that excitement a bit by highlighting that two of them wrote the book on artificial intelligence and law. And I don't mean that figuratively, I mean that literally. They wrote this book, The Legal Singularity: How AI Will Make Law Radically Better, and which just came out this month. And we'll share a link in the chat. So if you want to buy it, please feel free to do so. And on top of that, our other speaker founded a startup that was on a Forbes list of top 25 machine learning startups to watch. And the point is that we have very knowledgeable subject matter experts in a very relevant subject matter today. So please take the opportunity to ask any questions, which you can put in the Q&A tab at the bottom. And once our presentation is done, we'll reserve some time to answer some of those questions. And now I'll pass it off to our speakers to introduce themselves, starting with Benjamin, then Abdi, and then Sarup.
All right. Thanks very much for inviting us on and welcome everybody. I'll start off and tell you where I'm joining from. I'm joining from my office here at the law school at the University of Toronto, where I teach courses in tax law, law and technology. I'm also co-founder and CEO of BlueJay, which is a Toronto-based legal technology company that uses AI to predict legal outcomes. We also have a new product that's just coming onto the market now in the US that uses generative AI to assist with tax research. And so this system can answer virtually any federal income tax question that you throw at it in the US, and it's extremely exciting, and it's getting tons of traction. And exciting announcements as well coming in the UK and also in Canada with similar technology in the coming months. So stay tuned, and I'll pass it over to Abdi to introduce himself.
Hi, everyone. Thanks for having me. My name is Abdi Adid. I'm zooming in from my office at the University of Toronto as well, a couple of doors down from Ben, actually. We're right next door. I'm an assistant professor here where I teach courses in torts and procedure, as well as alternative dispute resolution. Prior to joining the faculty here full-time, I worked alongside Ben as the vice president of legal research at BlueJay. So I led the team of lawyers and researchers who helped to inform the products that Ben described. Alongside Ben, I'm also the co-author of The Legal Singularity and alongside Ben, a frequent commenter on issues related to law and technology. I'm very excited to be here, and I have a lot of respect for startup founders who are trying to make their way in what is sometimes hard to penetrate world of new ideas. And so I'm really keen to talk to you all and answer any questions you might have.
Hey everyone, Sarup Arwani. I'm co-founder and CEO of Senso AI. We're a Toronto-based company we just launched a new product for financial institutions to help them adopt large language models in their organization. Some of the use cases we do is help them ingest their policy and procedures documents to enable faster retrieval for areas like customer service and marketing and executive teams. It's going really well. We also have a number of predictive models that enable financial institutions to predict client behavior, and that's been in market for quite some time. Due to the demand of large language models and generative AI since the launch of ChatGPT, I also launched an organization called First Principles AI, which educates organizations, enterprises, and executives on the power of this, but also the risks as well, helping them think through governance, as well as some of the use cases that are helpful in industries, educating staff on things like prompt engineering, which I'm going to be talking about a little bit today. Thanks for the invite, Amit, and great to be here with everyone.
Thanks, Sarup, and Ben and Abdi. And so now that we're all well acquainted, I'm just going to give a quick overview on Founder Institute before we start the presentation on AI. So I'll just share my screen here. Okay, FI is the world's largest pre-seed accelerator that's helped over 6,000 founders launch venture scale companies that have raised over 1.75 billion with a collective valuation of over 35 billion. FI has over 200 chapters across 100 countries, and a vast majority of those are geography specific, based in many major cities. But our legal tech chapter is one of a handful of vertical specific chapters, so it's a global program. And with fundraising generally, most venture scale companies raise financing at certain intervals, starting with pre-seed and then seed and then series A, B, and so forth, with a view to ultimately get to an exit event, which could be an acquisition by another company or an IPO. Our FI Core program sits at the pre-seed stage. So it's designed to get you ready to launch your startup journey in a methodical way, including raising your first or second financing round. And how does it work? Step one is to find great people. So if you're looking to apply to our chapter, there's a link in the chat, and please feel free to reach out to myself, Halal, or another director if you have any questions. And once accepted, we provide you with a massive global network and structured training, followed by a lifetime of support through our ecosystem. We have the world's largest startup mentor network of over 25,000 mentors globally, but we'll also have legal tech specific mentors for our chapter. I believe a few of them are in the audience today, so please feel free to introduce yourselves in the chat as well. The core FI program is 4 months, and we meet on a weekly basis starting in October, and there are 2 tracks. One is the launch track, if you're very early stage and just starting, or 2, the growth track, if you already have a product and some early traction. Once you graduate, you'll have access to free additional structured programs that dive a bit deeper, including Founder Lab, that takes the training to a next level on the fundraising side and the product market fit side, and lastly, access to our exclusive FI Venture Network. And this is a glimpse of the overall FI ecosystem. And over here, we also have VC Lab, which is a structured accelerator program for VCs, which I actually went through personally. So there's a massive group of global VCs in that network who also get connected to FI graduates. So that's our quick overview, but you can always learn more or apply at the link in the chat. And now, without further ado, I'll hand it off to our speakers, starting with Sarup, who will give an introduction to AI and prompt engineering.
Great. Just going to share my screen. Can everyone see that?
Yep.
Good. Awesome. All right, great. Just going to go through the agenda that I'm going to be going through in 2 pieces today. So I think, like Amit, you mentioned, just start from the basics, pretend like no one knows really anything here. So I'm really going to just kind of handhold everyone through this. So I'm going to just start with an intro to prompt engineering, starting with like what large language models are exactly, definitions and essential components, and then in elements of a prompt. Prompt engineering is a very creative exercise, so there's many approaches, but I'll share one approach today, which I found helpful. And then Amit and I are going to go through a live legal tech example later in the presentation. Today's focus will be on text generation, since it's a legal tech, but generative AI spans multiple modalities, and a lot of these are starting to get very popular. So let's dive into what is prompt engineering, starting with the basics of what a large language model is. So a large language model is great at understanding connections between text. It's a prediction engine that takes a sequence of words, and it basically predicts the most likely next word. And it's trained on basically like the corpus of text that we've amassed across the internet over the last few decades. This is a nice infographic which shows some of the data sets that GPT-3 was trained on. So as you can see, Common Crawl, web text, Wikipedia are all popular. training data sets. And this is a big topic in legal right now, which data sets can or cannot be used in large language models. So this is an evolving field that I'm sure the other individuals on the call will be able to speak to more. Of course, why is this all occurring right now? ChatGPT and the launch in November really created a surge of excitement, and everybody's really been diving in, trying to figure out how to get the most out of these, but also how to really kind of think about how to deploy this in a responsible way within their organizations and within their lives. But again, fastest growing application in history. And there's not just one large language model. I like to equate this to electricity because there are many large language models out there, both centralized and decentralized. On the centralized side, we're probably all familiar with OpenAI, Google, Cohere and Anthropic is another one. Cohere, shout out to Toronto, Toronto-based company. And on the decentralized side, the open source side, which I'm a huge fan of the open source community is on complete fire right now. And there's quite a few emerging large language models out there that Meta and other companies are releasing, many of them that are, for commercial use. So really, these models, these pre-trained models are something you can kind of download and as a developer get started on building and fine tuning right away. So it's an exciting time in the field. So diving into what is a prompt. A prompt is the text that goes into a language model, and I'm sure everybody on the call is familiar with this using ChatGPT. Prompt engineering is the art of writing text to get the large language model to do what we want it to do. And it really is an art because the nuances of how you kind of form this text and structure this text really impacts the results. And we're just going to show some examples throughout the presentation. So this is a nice structure that I tend to use. Like as an engineer, I like everything structured, and I like inputting and outputting various elements of a prompt to get what I want out of it for different use cases. So this is how I usually structure a prompt. It starts with context, so external information or additional context that can steer the model to better responses. And I'll show examples of all of this. An instruction, a specific task or instruction you want the model to perform. Input is essentially the question or something you're interested in analyzing, which we'll look at later today from a legal standpoint. And the output indicator is the type of format of the output. And I'm about to get into a couple of examples here. So on the left over here is the prompt. As you can see, it's color coded based on like the elements that I went through before. And on the right, I'm going to paste in the response that comes out of this. So on the input side, I basically said, hey, list the comparison between using all 4 elements of a prompt and not using all. So instruction, context, input data, and output indicator. And then I asked for it in bullet point form. So the results did what I want. GPT-4 is pretty good at following instructions. And so it provided me a decent response. Just to show you the difference of what leveraging context and instructions and a deeper output indicator has on the same question is, so context, I basically guided it and saying, you were a senior researcher at OpenAI with extensive background in NLP and human AI interaction. Instruction, pretty much the same, and input really kind of just the same, pretty much the same thing. But from an output standpoint, I asked for it in a table with specific columns. And as you can see, it does a pretty good job with following these instructions. So really, it depends on what you want out of this, but this is sort of the before and after on how using different elements of the prompt can have an impact. Of course, the use cases are vast. And people are discovering more use cases every single day. So, text summarization, information extraction, question answering, these are ones that are everyone's familiar with. But things like generating prompts, using a prompt are starting to become very, very popular. Developing autonomous agents with changed responses. These are getting really popular. And these are emerging sort of use cases that everybody's starting to realize that, the power of something like this is much more vast than we initially expected. So these are ideas that I'm starting to share through my courses and through First Principles AI. So a couple of basic strategies and techniques, and these are just like the raw basics. there's a concept called zero-shot learning, one-shot learning, and few-shot learning. So I'm going to walk through each of these and I'll show you some examples. So zero-shot learning is really what the model has been pre-trained on. So that infographic I showed before, it's all the knowledge that is inputted there. And these are suitable for straightforward tasks without any sort of patterns or context requirements associated to it. One-shot learning usually involves a specific example where you want the model to follow a specific pattern. And again, this is useful for, if there's a pattern or an output pattern that you want it to follow, it's very useful for that. And then few shot involves multiple examples. And again, I'm going to show you a couple of examples on why each of these are relevant. So zero shot learning, an example is what is the capital city of Australia? And you get the result off the pre-training data. You don't need to provide it any context or instructions or anything like that. One-shot learning, so convert the following formatted date to its corresponding format. The input is the date to be converted, and the output is the format that you want it in. So as you can see, it follows it pretty nicely. So that's an example of one-shot learning. And then few-shot learning, as you can see in the context field, I provided a few idioms as examples. So break a leg means good luck, bite the bullet means face a difficult or unpleasant situation. Instruction is find the literal meanings for the inputted text, and input has a couple of examples here. You can actually assign an Excel sheet to this with many of these and get the outputs in an automated fashion. But as you can see, it does a pretty good job with finding the literal meaning based on the examples that I provided in a nice table. And of course, I can manipulate the output indicator to do this, like something like a JSON code block, and I can get the result like that. So the idea here is you can interchange various elements of the prompt to get different formats and different outputs based on kind of what you want. And it's all about structuring these, storing these in your own library, your own repository, so you can actually use these on a daily basis. And that's what I encourage everyone to do. That's where I've seen vast productivity enhances in my personal and professional life, and anyone I teach this to. All right, I'm going to stop there, Amit. Hand it over to you and continue on later.
Great, thanks, Drew. That was a great foundational base. Now we're going to take it to the legal side and hand it off to Ben and Abdi to talk about AI and law.
Sure. So I'm going to share my screen here. Just give me 1 second to do so. Can you all see that? Okay. So hopefully you can all hear me. So what we're going to share is some of the basic arguments of our book, but it's really important to talk a little bit about our particular contribution to this conversation. So Ben and I wear two hats in these discussions. So there's the one hat as legal technologists, and in Ben's case, founder and entrepreneur, who are building tools that are trying to help us navigate safely to the future, which is a technologized legal profession where we use and leverage computing power for the benefit of lawyers, professionals, but also the public that they serve. But the other hat that we wear is as academics who are thinking about the second and third order implications of all of this. And so in a lot of ways, we're well positioned to be talking about not just the great opportunities of using AI in the legal profession, but also about helping us sort of mitigate some of the risks, which in some ways are both perceived and real, but to the extent that they're real, we think are surmountable. Largely surmountable. And so the title of our book is The Legal Singularity: How Artificial Intelligence Can Make the Law Radically Better. So some context, you probably heard about the technological singularity or the economic singularity. Our notion of the legal singularity is rather straightforward, borrows a little bit from those, is inspired rather from those ideas, but it really describes the future state at which technology facilitates the ongoing functional completeness of the law. And to understand that statement, you have to really understand the status quo in the law today. The law is incomplete in a couple of regards. First, because the law is a deeply human enterprise and people are writing laws and making rules, the law can't begin to reach all aspects of human behavior and activity. So there's all kinds of things going on in the world for which the law has nothing to say to just yet. Then there's the fact that the law, in the way it's made, in the way it's analyzed, in the way that it is created and assessed and researched, is in many ways underspecified. That is, there are laws in how they're written that are ambiguous. There are laws that are hard for us to understand. There are laws that are really terse. There are laws that are highly complex. And in many ways, we're not always capable of putting our finger on exactly what the law is at a given moment. When we are, sometimes we have to do so through expensive professional intermediaries. Other times, we have to engage in these massive reform efforts to ensure that the law is actually speaking to our understanding of the world. And so there's a way in which the law is incomplete. And the legal singularity is this idea that using computing power, right? That's the predictive capabilities of AI, the generative capabilities of AI. We're able to get to a world where we have a sense of our legal rights and obligations in a real-time, on-demand way. So some background context. This is important, especially for the non-lawyers in the audience, to think about the history of legal information. The way that lawyers do their work, unless you're using some of these cutting-edge AI tools that we're describing, is not actually all that different than the way lawyers were doing their work in many centuries ago. So beginning at the advent of the printing press, you might say we were in the era of analog legal information, where lawyers were conducting their legal research and trying to answer legal questions by consulting these hardbound volumes like the ones you see behind me. That really continued for centuries and centuries until you started to see some of that information get platformed in what we call the digital era. So beginning in the 1950s and really taking off in the 1970s when the technology is more capable, but really only reaching the masses in the late 1990s and early 2000s, you start to see lawyers answering legal questions, performing their legal analysis by consulting digital databases. Now, the important thing to remember here is that those digital databases really did nothing more than create digital archive and compendia of information that we have in books. So you start to be able to conduct your research, find cases, consult treatises, look at textbooks through digital databases, but nothing new was necessarily happening through the technology except for highly effective search functions. Well, beginning around 2015, and with the proliferation of companies like BlueJay, you started to see something different, which is the era that we're in now, the computational era of legal information. What's different about the digital era and the computational era? Where the digital era was what you might describe as a mere platforming of analog brick and mortar legal research materials, the computational era took all that information, treated it as data, and started to perform functions on top of it. So using AI to help glean insights, to predict outcomes by synthesizing all of the historical case law, those kinds of things were made possible. And today you have generative AI tools which are taking that a step further. This is important because it gives you a glimpse into how dyed-in-the-wool some of the practices in the legal profession are. In many ways, there hasn't been a lot of significant change, but the one that we're enduring and have endured in the last few years has been seismic, really. Okay, so one of the main things that is now possible is legal prediction. Legal prediction is crucial to how lawyers perform their tasks. And beyond just lawyers, it's really crucial to how people make legal judgments or legal statements. So the important thing to know here is that prediction in many ways is the law's, what we call the law's long-held aspiration. Famous quote by Oliver Wendell Holmes, a well-known American jurist and scholar, said, "The prophecies of what courts will do, in fact, and nothing more pretentious, are what I mean by the law." What does that mean? That means that inherent in any legal statement is a legal prediction. So for instance, if I say I own a home, I might be saying that my name is on a deed somewhere, on a document somewhere. But really, if you peel it back, I'm really saying that if it came down to it and you challenged me for ownership of my home, I believe that a future court or a future authority would vindicate my property interest in my home. Almost all legal statements have this predictive element. And as a matter of fact, prediction is the way that lawyers do their work. When you advise a client, if a client, walks in your office and says, hey, I want to know about whether or not my transaction has economic substance. That is it going to be respected for tax purposes by the IRS or another tax authority? They're not asking you to explain them the contours of the economic substance doctrine. They don't want to hear a detailed description of the multi-step test. They want to know, how is my transaction going to be treated? What am I in for, right? The same way if someone is asking you, a criminal defendant is asking a question about their case, they want to know about what their exposure is, what the likely criminal sentence is, whether they'll be adjudged as guilty or innocent. They don't necessarily need a recitation of the finer points of the law, though you give them that as part of your professional capacity. But what people are really after is a sense of what's likely to happen. And technology makes that much more possible. Why? Take machine learning, for instance, right? If someone knocks on your door as a lawyer and says, hey, I'm trying to get a sense of whether or not, or how much severance an employee is entitled to after being terminated 3 months into their job. What would you do as a lawyer? You'd go and you would consult historical case law, but there's a limit to how much you can consult because there's a limit to how much you can read in a given day. Now, if you're using a piece of technology like BlueJay's predictive tool, for instance, that we developed over years of iteration and refining, then you can describe the facts of your case to the software, and much more quickly than you can, in fact, in a matter of seconds, it can consult all of the decided and relevant case law in that area. And that's a simple recognition of the human and computer division of labor, right? This idea that there's things that we're good at and there's things that computers are good at. And one of the things that machine learning can do is synthesize information in much larger volume than we can. And so why not use that to start us off from a higher floor, so that when I'm looking for an answer to that legal question, something can assist me by reviewing all the relevant case law, and it can surface information that I should consult, that I then reconcile against my professional judgment, my experience, my sense of the case, my experience with the judge, my knowledge of the client's needs and interests, right? And so it's in that partnership or that division of labor that so much more an effective prediction is possible. Okay, so this takes us towards a world in which people can get a sense of their legal rights and obligations in real time and on demand. If it is the case that you can predict how future courts are likely to rule, how future regulators are likely to treat a situation in their domain, then you really do have an authentic and immediate sense of what the law is on a given subject. And even more importantly, how it's likely to bind or affect you. And so if that's the case, and if technology is trending in the direction that we believe it to be, where there'll start to be, say, retail applications of these tools, where ordinary people can get a sense of their legal obligations, where institutions can be able to translate legal information more effectively, where courts can become more accessible, then where do we get to? Well, we contend in the book that we make a series of claims. First, that law can become better and more fair. Second, that dispute resolution can be dramatically improved. Third, that we can get to a place of universal legal literacy, where people, like I described, really have a sense of what the law is in a way that doesn't require them to have to, wade through the desert. And then lawyers, the role of the legal profession will become evolved according to our argument, more dynamic and more interesting, and in many ways more useful. And we'll have a more rigorous debate about not just what the law is, which is kind of where we're trapped right now, but we'll have some conversations about what the law ought to be, the more future-oriented normative conversations. And so I'll take you through each one of these and pause a bit. So first, this idea that the law will become more complete, but also fairer, clearer, and better calibrated. So one reason for this is that with the proliferation of big data, with our ability to get a handle on what the law is much more quickly, we can identify its gaps, right, rather easily. So that's one point here. Another is that there's a way in which technology allows us to identify, perhaps more effectively than through our traditional analog methods, whether the law is adequately serving the kind of interests that we want it to serve. So for example, we have a set of laws that many of you are familiar with, which determine how a worker ought to be classified as an independent contractor or an employee. Well, whether someone's classified as an independent contractor or an employee is in many ways a touch and feel test, according to the courts, right? They look into a bunch of different factors. They look into, does the worker control their own schedule? Do they participate in any of the downside risk of the enterprise? Do they use their own tools? Are they able to take on additional work? There's a non-exhaustive list of factors that courts consider that aren't present in every given case. In some cases, someone wears a uniform. In other cases, they don't. In some cases, they drive their own car. In other cases, they don't. They still might be one or the other. And so for a human being to really provide rigorous legal advice on that question, they'd have to be well experienced. They'd have to have a sense of how things are played out in that area. And they'd have to be able to ingest quite a lot of cases with disparate holdings and disparate fact patterns and disparate rulings. Well, this is the perfect kind of situation for machine learning and for technology that's parsimonious, that is able to attend to all these factors and pay attention to large volumes of information. And so what do you get? Not only do you get a prediction as to how your worker, let's say you're an employer or company, how your worker should be classified, but those of us who are observing the law, who are making decisions or about whether a law should be reformed or rewritten, can kind of see the various ways where misclassification might occur. We can kind of see the empirical reality of the law and whether or not it actually meets our approval or serves the interests that we wanted to serve much more easily because we're taking this landscape view of the law. And so in some ways, we can make it much more fair. Better dispute resolution. So one of the frustrating things about judging today, especially if you look at appellate court decisions, I can speak for Canada and the US, but I'm sure this is true of at least the common law world, is very often there's a back and forth about that predominates the dispute about what exactly the operating law should be, the governing law should be. What exactly are the touchstones for resolving the dispute? In other words, there's a back and forth about what the law is. If we got to a place where we could stipulate what the law is, or there was a consensus understanding of what the law is, not only would you and I be better capable of structuring our behavior before we get to the courts, but the courts can start to pay attention to some of the other live considerations that exist in a dispute. For example, what is a socially optimal way of resolving the problem? What is the fairest way of resolving the problem, right? Sometimes the wrestling match over what the law is and just trying to put our finger on the elusive law of it all makes it such that we're not always paying attention to the best way to dispense justice in the case. Other times, we, because of that back and forth, we sometimes obscure some of the important elements of the case and the important role of dispute resolution, like helping us decide what the law ought to be in future such cases. And sometimes this happens in ways that frustrate people, especially frustrate the broader public. So, for instance, I teach torts, and one of the things that I teach is the sort of wave of cases that happen after the quote unquote Me Too movement, where there's workplace harassment and such being alleged. Well, if you read those cases, you read the appellate court decisions about that area of case law, you see very little reference to harassment or like what actually happened in these disputes. You see instead ongoing attempts to clarify what the right case should be or what the right reading of the statute is. Well, if we got to a place where we could sort of stipulate what that is, then we could have the conversation about, well, what actually happened in this scenario, and what do we think is the right level of scrutiny, the right amount of punishment, the appropriate social sanction for this kind of behavior. That, I submit to you, is a sort of richer place for us to be as a legal community. Universal legal literacy, the law being knowable everywhere and on demand. So this is one of the great potential benefits of increased use of AI in the legal profession and in legal institutions more broadly. Universal legal literacy. So it is the case that a lot of people, sometimes us who have legal training, but often lay people, don't always have a sense of how the law operates on them. right? So sometimes you go and you are able to acquire legal advice such that you can sort of structure your behavior. Like if you're a founder and you're trying to figure out the tax or regulatory environment that you operate in, or how your IP should be treated, or what kind of privacy regulations you have to comply with, you have to obtain expensive legal advice for that. And that can be good because expertise is a good thing and people have contributions. Lawyers have much to contribute to founders with respect to how they should be thinking about some of these complicated issues. But other times, you could really benefit from, in that situation and many other situations, you could really benefit from having a sense of what the law is so that you don't step on a landmine and you don't fall for one of the tripwires. You have you're able to sort of confidently maneuver and participate civically and socially to your full capacity. And knowledge of the law helps you do that. It also helps to undermine a really curious thing in our profession, which is the access to justice crisis, which everyone kind of agrees is a problem. There's the issue of access to justice or inequitable access to courts and legal services is as close to a consensus point as is possible in the legal profession. Yet there's some resistance still to technology helping to resolve that. Well, if we can start by allowing legal answers to legal questions to be easier to access, more cheap to access, more widely accessible, then you help to perhaps even halve the access to justice crisis, because people will really have a sense of how the law operates on them. They'll know which disputes to pursue and which ones not to, which ones to settle. And all of that, I think, helps to declutter our judicial institutions and give people the kind of confidence that they need for full civic participation. Evolve lawyering. Okay, this is a really important one, because one of the things that Ben and I constantly confront in these conversations is people understandably quite worried about the future of the legal profession. Am I going to be automated out of a job? Is ChatGPT going to replace me? And one of the things that we often say, which has become a common refrain for us, is, AI is not going to replace lawyers, but lawyers that use AI are highly likely to replace lawyers that don't. Why? Because there's a way in which right now the profession is accommodating more drudge work than it ought to, right? There isn't a lawyer that I meet who wouldn't rather be spending the bulk of their time involved in strategy or creative thinking, problem solving. But instead, upwards of 20+% of their job is attending to administrative stuff. Of that remaining 80%, a significant amount of it is just trying to corral the information they need to problem solve and be creative, like legal research or due diligence or all of these things, contract review, all of these things that actually technology is pretty well positioned to do. Now, if you leverage that appropriately, you can free yourself up to be able to devote more of your brain space to that creative, challenging, dynamic remaining percentage of your job. Now, you could do that. You could also take on more cases so that you can economize and actually just be more effective across the board to many more clients. But really, the core of this is recognizing, what did we go to law school for? What did you want to be a lawyer for? You didn't want to spend all of your time trying to navigate a legal research database and find the case that stands for the principle that you're looking for. You dreamed of having the moment in the courtroom. You dreamed of being able to deliver value to your clients, being a problem solver, being a go-to expert for your legal mind. So let's free up more room for you to be able to do that. And technology promises to do that in so many ways. Look at the proliferation of contract review software, due diligence software, e-discovery software, legal prediction software like BlueJay. Now with Ask BlueJay, which is the tool we're building for, the recently released tool that allows you to get answers very quickly to complicated federal tax problems in the US, because it's been trained on the entirety of US federal tax law. You can start from a legal answer that is more informed often than your gut instinct will be, right? That just gets you 80% of the way there, perhaps. And so lawyers can be free to be much more dynamic. Now, social problems will evolve, of course. Technology, because it threatens to disrupt so many different areas of our life, there's going to be new issues, new legal issues generated. And lawyers, this is what I tell them a lot. Wouldn't you rather be equipped to do the kind of thinking to help resolve those issues than to sort of be dealing with yesterday's problems, which technology has, in a highly effective and accurate way, helped you sort of get over that hump already? More rigorous debate. This is a pretty important one, which is technology sort of disinfecting power. I often share the example with people of, imagine that we built a tool tomorrow that tried to set optimal wages. And it said, everyone's wage in their next job is going to be set algorithmically by this tool. And so you upload your resume or you connect your LinkedIn page to this tool, and it spits out what you should be paid at your next job based on your experience, based on your resume history, and employers all subscribe to this. Okay, let's say that tool was built. We have all kinds of problems with this kind of tool being built, of course, right? But if we built a tool like that and we didn't instruct it, didn't give it any other special instructions, what's one of the things that would happen? Well, maybe the tool would start to penalize people for gaps in their resume. That might manifest as a amplification of, say, the gender wage gap, for instance, right? That's not something that we would accept. In fact, if that happened, I think we would talk about decommissioning this piece of technology immediately, right? We wouldn't stand for it. Yet the gender wage gap persists in our society, but it persists in a diffuse way. It's embedded in institutions and relationships, and we've sort of lived with it. And so there's a way in which technology brings things into stark relief in a way where we say, this has surfaced the problem in a way that that everyone kind of understands and is able to zero in on. Let's solve the problem, right? And so that sort of disinfecting capacity of technology, I think, is one that's going to lend itself well to really wonderful and rigorous debate. You're seeing this right now in the world of criminal justice, where in places like Broward County, Florida, or in social benefits administration, places like Little Rock, Arkansas, you're seeing that algorithms have the algorithmic decision making has occasionally led to the reflection and amplification of some underlying bias, and that's led to really robust conversations around what kinds of things should we take into account in probation and sentencing, what kinds of factors should we take into account in healthcare administration, and it's leading to a kind of debate where the defensiveness of the previous analog debate, there's kind of no room for it because the technology has made it very obvious, right? Where some of these biases manifest. It's not just saying you have an unconscious bias. It's saying, look, the data is producing a result that we find to be socially untenable. What do we do about it? Right? And so that ability and that capacity, I think, is going to lead us down the path of a more informed and thoughtful debate going forward. The other thing about this is, and this is something that everyone just has to accept, this stuff's going nowhere, right? It's the future of AI is rich. It's going to be surprising and exciting and perhaps concerning for some people, but it's definitely not going anywhere. In fact, there's been significant investment. The largest law firm, or the second largest law firm in the world, Baker McKenzie, has an in-house machine learning team, Baker McKenzie Machine Learning, where they're actually building bespoke tools for their own internal use. You see that some of the large accounting and consulting firms are investing billions of dollars into AI, especially in generative AI, right? And then, of course, you see that our legal institutions are starting to, in their own way, sometimes clumsily, use these tools. And they're actually looking to, people like yourselves and certainly folks like Ben and I for some guidance about what the responsible and appropriate use is, right? I was just reading the other day about a judge in Colombia that used ChatGPT for part of his ruling. And sometimes they're misapprehending the nature of these tools. Like some of you have heard about the lawyer in New York who submitted some hallucinated case law to the court. It's unfortunate for that guy, but it's good for us because now we're having a great conversation about what responsible use is, and people we're looking to people like Sarup to help educate us on prompt engineering, which is going to be an important skill, which Ben and I have said before, like lawyers should be good at. We're supposed to be good at asking questions. Let's embrace the possibility of turning that skill into the capacity to elicit great results from technology. And so all of this is to say, we're optimistic about the future. We're mindful about some of the downside risks, but we're really hopeful that with some concerted effort, we can mitigate them. And the book is really a step towards that. If you see the subtitle of the book, it's called How AI Can Make the Law Radically Better. That's a deliberate choice. We didn't say how AI will make the law radically better, because it's still up to us in many ways to ensure that we land the plane safely. And we think that we certainly can, but it's about listening. It's about participating in the robust debate. And, respectfully, it's about also reading our book and giving us an audience. So thank you all.
Thank you for that, Abdi. Super, super interesting. I'll definitely dig deeper by reading your book. Now we're going to shift gears once again and do a live prompt engineering example. So Sarup, over to you.
Everyone see that? Great, perfect. Abdi, that was super insightful. Thanks for sharing that. It was awesome. So I'm going to be walking through a live example based on some of the concepts that I shared before. The technique that I'm about to illustrate is called expert guidance, and these are just instructions that provide time for the model to think. And if you provide explicit guidance in the prompt, the results are consistently more detailed, accurate, and thoughtful. So Amit and I have prepared an input. We'll go through the prompt after, but Amit, maybe you want to cue this one up.
Sure. So the scenario here is that Sarup is a founder who's now doing his first real financing round led by a VC. And the process starts by the VC sending a term sheet. Now, sometimes term sheets are negotiated before lawyers get involved. So Sarup needs to understand what the provisions mean. And one in particular is around board composition. And that's right here on the right-hand side of the screen. So Sarup starts by asking ChatGPT if there are any industry standard, documents or resources to consider when drafting board composition rights for a venture scale startup in the US. A model precedent, the voting agreement of the National Venture Capital Association, is one of several recommendations. So Sarup uses that, and that's here on the left side, the model precedent. And now Sarup will do his thing.
Great, thanks, Amit. So I'm going to walk you through a prompt. It's a bit of a detailed prompt, but again, details matter when it comes to what I call expert guidance. So context is what I shared before. It's really kind of like being specific. You are an expert legal advisor with extensive background in understanding the NVCA voting agreement. I was specific there. You can be a little bit more broad. You don't have to be specific into the actual agreement. But I find that it helps in some aspects. It is more work, but you could try the broad one. This is where the instruction is where expert guidance comes in, and these words can just be generic, so you can cut and paste and sort of like fill in the blanks where needed. But the key points here: identify the key components of both the standard and provided clause, analyze each component separately to identify its legal implications, summarize the overall differences and potential risks between the standard clause and the provided clause, present your findings in a tabular format, which I also reinforce in the output indicator. Sometimes repetition's good, I find. And don't make any final judgment on the provided clause's overall potential risks and unique elements. So these are just 5 things that, again, the model actually kind of iterates itself and helps it think through this in a more thoughtful manner. As you can see, I provided inputs for the standard clause and the provided clause, and the output indicator, I specified the columns that I want, as well as in table format. So with that, I'm going to actually do this live and cut and paste the examples. So just going to drag and drop. Amit, can you see the browser? Perfect. Just going to zoom in there. So I'll start by cutting and pasting the prompt. And Amit, you can share this with the group after, we can share the deck or whatever needed. So cut and paste that. So that is pasted in there. I'll get the standard first. and then I'll take what was sent to me, the founder. All right, see what it comes up with. Amit, you want to start running through these?
For sure. Interesting. Yeah, so myself and Sroop have gone through this exercise before, and what's really cool about it is for the most part, it highlights the major risks, but sometimes it's presented in different ways. So if you're doing this, for your practice or otherwise, it might be a good idea to do it more than once, right? So here's a good one, right? Just generally a couple things to flag, right? Here in the term sheet language, the VC gets a hardwired board seat, but there's no requirement for them to maintain ownership of any shares, right? And if you can see my screen here, I guess this is the third column in the third row. And so I've actually seen this in practice before, right? Both from an investor perspective and a founder perspective. And that doesn't make much commercial sense, because theoretically that investor could sell all their shares and not have any ownership in the company, but still have some control of the company with a hardwired board seat, right? So that's definitely a great flag. Let's see what else we have here. Another one is right here, the 70% threshold, right? So the clause has a precise threshold providing more certainty. So the key holders are essentially the founders, right? And so the founders get diluted at each round of financing. So a 70% threshold could be pretty high, right? So what Sroop and his co-founders should look at is what they collectively own currently, and then assume a 15 to 20% dilution at each round. And see at which point they lose that hardwired board seat. If it's too soon, they may want to push for a lower threshold, right? So that's another important point here as well. The third point about the independent director. So that's also an interesting point to highlight. So there could be a deadlock on the independent director. So Sroop as a founder should ensure that there's an odd number of directors, right? And if not, having the chair or someone else that gets a deciding vote, if that ever ends up in that type of situation. So yeah, I think it's done a pretty good job of highlighting these issues in 30 seconds.
Well, to your point, Amit, I always kind of like actually do go through this exercise more than once to see what the model comes out with. The models are getting better over time, but even GPT-4 tends to have different results each time. So the point is, critical thinking is still a very important element as you being the human in the loop here. It just allows you to get that starting point done a lot faster. For someone like me, it allows me to get 80% there, but I still need my counsel to ensure that they vet that. But getting 80% there is really kind of like really important to me to have that base understanding before going to my counsel. So hopefully this was helpful, and Amit, feel free to share the prompt out when needed.
For sure. And probably one other point I would add to that is that the good thing here is that Sroop as a founder shouldn't be shy to bring up any of these points, because they're all deviations from the market standard precedent. Right. So in practice, a VC will likely have more bargaining power, and may get some of these still. But the point is that Sroop and the investor can have an informed discussion, at a stage before agreeing to anything or even incurring legal costs. Right. So just the exercise of kind of understanding all of this is very valuable to early stage founders, I think. So I think that's all we have from our panel. And we have some time left, so I would love to jump into some questions. And let me pull some up. Okay. So we have one earlier question. So this is for Ben and Abdi. So law is one of the most conservative sectors, and lawyers themselves are conservative customers. It appears that's changing, but can you provide your view if you believe that's true? And if so, on the pace of that change?
So I could see from Abdi's gesturing that he thought I should take this one. You know, I think lawyers, first of all, lawyers are tough to paint with a single brush. There's so many different lawyers with different attitudes, approaches. It's tough to make generalizations stick about the legal profession. One thing is true, many lawyers are really quite sophisticated consumers of tools, services, technologies. And so they tend to be quite careful about the sorts of tools that they take on. That can cut both ways. So when a tool really, really works and has a clear economic case for adoption, you can see extremely rapid adoption by lawyers. At the same time, there are business model issues with a lot of technologies that people often try to sell into law firms. And so if you're trying to pitch a product that aims to save a lawyer a massive amount of billable time that they're not going to be able to recover from their clients, it's going to take a little bit longer for the market to adopt that, and some enterprising early adopter law firm partners to say, we want to do this because we think it's going to give us a competitive advantage vis-a-vis those other firms that are kind of dragging their heels a little bit and don't want to adopt it. Eventually, everyone will get drawn into the equilibrium in which everyone is using that time-saving technology. But because the lawyers are selling time, they're not dummies. They understand that that's actually not something they should necessarily rush into. Where you can see really rapid adoption of technology is in an in-house setting, where if you have technology that is just going to cut down on the amount of time that in-house counsel are using to advise their employer, or if it's a clear substitute for going externally to something, and you know, in-house lawyers can really save a ton of time and effort and maybe external spend, you're going to see more rapid adoption of those kinds of tools. And so I think overall, my point is, lawyers are really sophisticated. They're really clever. If you come up with something that is materially going to help them, they're going to recognize that and they're going to adopt it. They're also going to understand what their economic self-interest is in a lot of these circumstances, and they're going to respond accordingly and predictably. Also, you know, the other thing that's going on is lawyers are often extremely busy. And so they're spending a lot of time not exploring new technologies that might actually help them out. And so, you know, you need to look for a little bit of daylight to find the lawyers who are going to have some time and want to take a call. So overall, I think it's probably fair to say that lawyers are a little bit slower sometimes out of the gate at adopting technology, but it's not because they're overly conservative necessarily. It's because they really understand their self-interest, and they can be, you know, harsh critics of technology that isn't quite fully functional and able to do what they want it to do.
Great, thank you for that. I still be mindful of time. I think we can squeeze in maybe one or two more questions. We have one from Zara here. And the question is, when we talk about global law, how do we rule out language barriers and difference in punishments in different countries, like the issue of awarding death penalty in criminal law? Some jurisdictions advocate for death penalty while others don't.
Wow, it's a tough question, of course. I mean, the main thing I will say is that there's no AI tool right now that can be ignorant of jurisdictional differences in the law. And so you can't build, say, a predictor tool or any kind of software that isn't attentive to the fact that there are different legal contexts, different legal cultures. And so I think what we're looking for right now is for a groundswell of legal tech entrepreneurs to build tools that are sensitive and understand the legal cultures and the jurisdictions that they come out of. And so law right now is geographically bounded. There are international laws, of course, but even those are often interpreted and executed through local legal institutions. And so we're a long way away from the omnibus general global legal AI tool. And so it's the most I can say about that. And when it comes to using AI to write laws and to sort of engage in legal reform, then I think there's potentially some more promise there, because if it is the case that we can sort of more effectively see what's working in different places and are able to make the empirical case for certain kinds of laws having, say, better deterrent effects than others, then you hope that that starts to lead to a normative cascade and people can start to think about converging around better law. But until there are no states anymore, and until there are no different legal codes, then we're probably still facing that problem.
Thanks for that. One more quick one. So this might be a Sarup question. So we have Katya who's asking, clients are still very demanding for individual attention. So with ongoing individual emails, I can't figure out how ChatGPT will answer them. So is there a way to leverage ChatGPT for individual emails?
I mean, right now it's fairly manual in terms of, inputting. If you want something out of your email, it's like inputting it in ChatGPT. But most of these tools, Google and Microsoft, are introducing embedded tools within Gmail and Outlook. It's already, in pilot across a number of their tighter group of clients, but it's going to be broadly available, I'd say, in the next 6 months. I hope I answered the question.
Yep, I think so. And so we are out of time now. So just wanted to, thank our speakers again for those so many great insights in this presentation. And we at the FI Legal Tech chapter really appreciate your time. I know the audience must have got some solid value out of this experience. And audience, once again, if you're interested in our program, please check out fi.co/legal-tech or reach out to our team. Our next event is a fun one where we're going to have startups pitching live to legal tech investors on August 8th at the same time. And our friends at the Legal Tech Fund are also hosting their annual Legal Tech Startup Showcase in December in Miami. So if you're a legal tech startup, you can apply at the link that Halal will share in the chat. And the deadline for that is July 28th, so apply soon. And that is a wrap. Thank you again, everyone. Take care.